Hi, I'm Mike Muston. I'm a partner in RWK Goodman's private client team, and I'm here today to talk about contesting a will. So there are a variety of grounds upon which a will may be challenged. When we are approached, there tend to be two main areas that crop up in conversation. The first of those is whether the person making the will may have lacked mental capacity. The second of those relates to concerns as to whether the person making the will was potentially unduly influenced in some way. However, there are other grounds that we will also look at. The first of those is formal validity, so whether the procedural requirements were met when the will was made. Second of those was whether someone knew and approved of the content of their will. And we may also look at whether there was some element of fraud or forgery. There are, separate to those areas, other types of case which do not technically involve challenging the validity of a will, such as a claim for financial provision by a family member or financial dependent. Simply put, no. This is because a will only comes into effect on a person's death. Prior to that time, provided that a person has the required mental capacity to do so, they can make a will as many times as they wish. There may, in other cases, be a separate procedure that may be followed through the court of protection, known as a statutory will, for when someone has lost mental capacity. Those cases don't technically involve challenging the validity of a will, but nevertheless can be very contentious, and they are complex claims to pursue. It's therefore important to have specialist advice on that area before proceeding down that path. Yes, you can contest a will after probate has been granted, but it can become more difficult to do so. The grant of probate authorises the executors to gather in and distribute assets to beneficiaries. Once assets have been distributed, even if your claim is successful and you have a court order, it can still be very difficult to recover those assets. So no contest clauses are added to wills to discourage named beneficiaries from raising a challenge and potentially delaying the administration of an estate by some time. It's therefore important to consider at the very outset whether your claim is likely to have merit or whether you are simply risking the loss of the inheritance that has been left for you. So the starting point is to look at the effect of a successful will challenge, and that is that the will would be declared invalid and the estate will be distributed either under the terms of a previous valid will or under the default rules of intestacy. In order to be able to bring a claim, you will need to be a beneficiary under an earlier will or stand as a beneficiary under the default rules of intestacy. If you are not in one of those classes, you will not be able to bring a claim. So primarily, your claim will be against the beneficiaries named in the most recent will, particularly those who stand to lose out if the content of the will changes. Also involved will be the executors and personal representatives of the estate. However, they will be required to remain neutral in any action. Their role is to provide information about the value of the estate and then to comply with any agreement reached between the parties or court order relating to an adjusted distribution of the estate. The starting point is that each party will bear their own costs. However, if a matter goes all the way to trial and a decision is made by the judge, the general principle that the loser pays the winner's costs is likely to apply. It is fairly rare nowadays to see that the judge will simply order that all of the costs must come out of the estate. We are mindful that it is a major concern for clients as to how their legal costs will be funded, and we are happy to discuss the various options that may be available, looking what is most suitable for you. So once you have made your initial inquiry, if it seems that your case is worth pursuing further, we will invite you for a no obligation discussion with one of our lawyers, and we will consider as part of that which type of case is appropriate for you. If that case involves challenging the validity of a will, we are likely to start by making inquiries into that will-making process. If that involved a will made through a solicitor or a will writer, we will contact that solicitor or will writer to seek further information. We will also look at entering a caveat at the probate registry, which is designed to prevent the probate process from proceeding, and that in turn will prevent assets from being distributed. If we still proceed further from there, we may look at getting in medical records or statements from relevant individuals who may have something to offer about the circumstances in which the will was made. Once we have then gone through that process, we'll spend some time considering that evidence and undertaking a further review of the merits of your case. If you have any queries about contesting the validity of will, please do not hesitate to get in touch with us at the private client team at RWK Goodman. Thanks very much for watching.